Good evening, everyone. I hope you're all doing well on this strangely snowy, sunny April day in Boston. If you missed the snow, there was about 3 minutes of it in the middle of the day. All right, I'm Interim Dean John Goldberg and a member of the faculty here, and I am delighted to welcome you all to celebrate the appointment of our wonderful colleague, Professor William Rubenstein, as the Bruce Bromley Professor of Law. Before I sing Professor Rubenstein's praises, I'm going to say a few words about the namesake of his chair. For more than 50 years, Bruce Bromley was associated with the firm of Cravath, Swaine and Moore. It was his partners, particularly William Marshall and William Schrank Jr., who first thought of a law school professorship in his honor, although friends and family also contributed. Bruce was born in Pontiac, Michigan in 1893. Following his graduation from HLS in 1917, he served in the U.S. Navy during World War I. In 1923, he joined what was then called Cravath, Henderson, Leffingwell, and de Gurdsdorf. Didn't know that. Except for a year of service as an associate judge for the New York State Court of Appeals, he remained with the firm for his entire life. As a senior member of the firm's litigation group, Bruce represented clients such as CBS, General Motors, Bethlehem Steel, and Westinghouse. Along the way, he participated in several cases before the U.S. Supreme Court, and I'm going to mention two of them. Both of them are about 75 years old, but they're still relevant. In 1946, Bruce represented Esquire magazine, which challenged Postmaster General Frank Walker's revocation of its permit to circulate through the mails based on Walker's judgment that it contained indecent, vulgar, and risque content. A unanimous Supreme Court, this is Esquire, a unanimous Supreme Court ruled for Bruce's client, concluding that Walker's revocation amounted to a form of government censorship that is, quote unquote, abhorrent to our traditions. 6 years later, in 1952, Bruce represented Bethlehem Steel in a case some of you may have heard of. It's referred to these days as Youngstown, or the Steel seizure case, and to this day provides the legal framework for analyzing the limits of presidential power. So, distinguished practitioner, accomplished litigator, trusted advisor, esteemed colleague, defender of civil liberties. Each of these phrases applied to Bruce Bromley, and each of them, of course, applies in equal measure to Professor William Rubenstein, to whom I will now turn. Professor Rubenstein is, as you know, a world-leading authority on complex litigation. He is the author, co-author, or editor of 4 books and more than a dozen scholarly articles. Since 2008, with some help from a few HLS students, he has edited the authoritative now 9-volume treatise, Newberg on Class Actions. In its latest edition, it is rightly been retitled Newberg and Rubenstein on Class Actions. Bill, if I may speak less formally, has also litigated, consulted, and served as an expert in myriad cutting-edge mass litigations. Federal courts regularly appoint him to provide expertise on issues ranging from class certification to attorney's fees, and to serve as a mediator to resolve our most complicated and high-stakes civil suits. After graduating from Yale College and Harvard Law School, both magna cum laude, Bill clerked for Stanley Sporkin in the U.S. District Court for the District of Columbia. He was then awarded a Harvard Fellowship in Public Interest Law to help start an AIDS project at the National Office of the American Civil Liberties Union. From 1987 to 1990, he served as a staff attorney with and then director of the ACLU's National LGBT and AIDS projects. There, he litigated cases in courts across the country and oversaw the ACLU's national litigation docket on these issues. Among these cases was the landmark case Braschi versus Stahl Associates, decided by the New York Court of Appeals. Braschi was the first court decision in this country that conferred on same-sex partners legal rights previously enjoyed only by persons in heterosexual marriages. While practicing at the ACLU, Bill taught courses on sexual orientation and AIDS law at Harvard and Yale, and authored the first law school casebook in the area, now entitled Cases and Materials on Sexuality, Gender Identity, and the Law. From 1997 to 2007, he was a member of the UCLA faculty, earning the Rudder Award for Excellence in Teaching. He's joined our faculty in 2007, and in 2011 was awarded the Albert M. Sachs Paul A. Freund Award for Teaching Excellence. As these honors demonstrate, Bill is an extraordinarily gifted teacher, and as I suspect some people in this room know all too well, I, for one, can attest firsthand to his greatness, and here is how, although I must confess there's going to be a little bitter undertone to my comments here. For many years, it was my fate to teach torts to the same 1Ls to whom Bill was teaching civil procedure. And let's just say I now have a clear sense of what it would be like to run a 100-meter dash against Usain Bolt. So, shame on you. Bill has also earned the respect and trust of lawyers and judges around the world for his mastery of the tangled and ever-shifting landscape of complex litigation. In this respect, his name belongs in a pantheon occupied by true legends of civil procedure, such as my former boss, Jack Weinstein, Arthur Miller, and Judith Resnick. Still, what makes Bill special, I haven't even mentioned yet, so I'm going to do that now, and then I'm done. The first is his ability to straddle the boundary between the bar and the academy, to function simultaneously as a true scholar and a fully invested practitioner. I've seen firsthand his ability to thrive in these very different environments. Few of us try to pull off this balancing act, much less succeed as splendidly as Bill does. Second, there is Bill's genuine, restless curiosity. As you've heard, in his legal career, Bill has reinvented himself several times, from gay rights advocate and scholar to civil procedure and complex litigation guru, and now, most recently, to teacher of legal profession, which, if you're a dean of a law school, is the highest calling anyone could aspire to. To develop and pursue this range of interest and expertise is as rare as it is admirable. Third, and most importantly, Bill is a trusted advisor, the sort of person to whom you go with a really hard problem, who listens as much as he counsels, and who invariably has real wisdom to offer. No wonder he is in so much demand. For all these and many other reasons, I am truly, truly grateful to call Bill my colleague and friend. Please join me in congratulating the Bruce Bromley Professor of Law, Professor William Rubenstein.
Thank you. When I took my seat in Arthur Miller's civil procedure class, my first day of law school, September 6th, 1983, 2,000 people in the United States had in the prior months died of a rare illness so exclusively among gay men that the media called it the gay plague. And the Centers for Disease Control, their official name for the illness was gay-related immune deficiency, or GRID. HIV was not identified until my second year of law school, and a test was not available until my third year. That year, the ACLU hired one lawyer to start a new national lesbian and gay rights project. I secured a fellowship funded by my classmates at Harvard Law School to join her and to launch a national AIDS project. The two of us doubled the number of lawyers in the United States working on lesbian and gay rights issues. We were making up new jobs. So rare and so disfavored was the endeavor that while studying for the bar in Langdale, I ran into one of my classmates, and after I confirmed the rumor I was going to do gay rights for a living, he looked at me and said, "You've committed career suicide." I traversed the vast expanse of that majestic reading room to a large stand on which stood an enormous Black's Law dictionary. And I flipped open to the C's, scanned down to career suicide. There was a one-sentence definition. It said, "You will never be the Bruce Bromley Professor of Law at Harvard Law School." Here I am. Yeah, how'd I get here? John the dean has very graciously given you the varnished version. I need to strip off a few layers of the veneer and provide some context. And I propose to do that with a hypothetical, followed by some facts, and then a summing up. Here's the hypothetical. Imagine that you're at a university that is under attack. Its funding is threatened, and it has instituted a hiring freeze. The law faculty convenes. Someone asks, how bad is it? Wanting to convey the seriousness of the situation and knowing his audience very well, the dean, and by the way, at this point you can interject, interim dean is fine for the hypothetical. The dean says to the gathered faculty, it's bad. You might each be called on to teach civil procedure. I'm 100% certain that if you had asked that audience at that moment to identify the most upsetting impact of the 2024 presidential election on the entire world, the one thing all would have agreed upon, regardless of all other affiliations, is that the possibility they might have to teach civil procedure should be at or near the top of the list. The dean knew his audience well. Civil procedure is a punchline. Even professional responsibility would not have sufficed. Civil procedure is the bottom of the bottom of the bottom of the barrel. Now, some facts. I've taught civil procedure 42 times in the last 30 years. I've led hundreds and hundreds and hundreds of students up a hill called Pennoyer versus Neff. I've left shockingly few of them to die on that hill. I've made jurisdictional statutes, even the supplemental one, make sense. I've unraveled the mysteries of both Twombly and Iqbal. I'm aware that Harry Tompkins lost his right arm at a railroad crossing in Hughstown, Pennsylvania in 1934, but he only did so one time. Whereas 42 times, having uttered the phrase, please open your books to Erie Railroad Company versus Tompkins, I can't help but feel I've given more of myself. I've written 9 volumes to simplify class action law. I've enabled generations of students to go home for Thanksgiving, preening among the yams and the cranberries and the pumpkin pie about their understanding of non-mutual offensive issue preclusion. Yes. Even if upon return in December, not so much. Perhaps most importantly, my students will attest, I've even gone to enormous lengths to try to comprehend and in turn explain things completely outside the realm of my own expertise, such as the peculiar magnetic pull a football banquet exerts over the will of a heterosexual man otherwise successfully avoiding service of process. So to sum up, in return for this lifetime of blood, sweat, and tears, at the very bottom of the barrel, you've now awarded me this: a few pieces of wood molded into a shape to fit a rear end, to which you assign the word chair, and with which you fully convinced yourself we're now even. All right, in fact, this chair really is very special to me. As it closes in on a half century of existence, only 3 professors have held this chair. The first was my federal courts professor, Paul Bator. The second was my civil procedure professor, Arthur Miller, who was famously the Bruce Bromley Professor of Law for nearly a quarter century. When Arthur departed, the chair went back across the aisle to the federal courts side, to the university's current provost, John Manning. When John became the dean of the law school in 2018, he met with each faculty member individually, asking what he could do for them. I assume he expected words like higher salary, bigger office, lower teaching load. So his face registered some shock when I said simply, I want your chair. If in 1983 you had told me that in 2018 I would be responding to John's question, why that? With the simple phrase, because it was Arthur's chair, You would have been able to knock me over with a feather. I could not have foreseen any career trajectory that would lead to that moment. Indeed, I'm sure in 1983 I would have considered that trajectory to be precisely the definition of career suicide. Characteristically, John could not have been more gracious in ceding the chair back to the civil procedure faculty. Dean Manning's work aside, Dean Manning and Professor Fallon's work aside, I have long felt that many questions that constitute the course on federal courts exist solely in the clouds. So I experienced the chair's return to a proceduralist as similar to the return of those astronauts who were stranded on the space station for a year, but finally made it back to solid ground, tethered by the reality of gravity. I may need to teach that little chair how to walk again. At the outset of my own career, I jumped into the deep end. My clerkship ended on a Friday in August 1987. The following Monday morning, I filed a lawsuit called the National Association of People with AIDS versus Ronald Reagan. And that Friday, I stood in front of a federal judge in the courthouse at which I had clerked. And after the government's lawyer announced he was there on behalf of the people of the United States, I stood and said the first words I ever said in a courtroom. I'm here on behalf of people with AIDS. Perhaps sensing my nervousness, the judge leaned down and said, "And what is it that they want, counselor?" I thought, what do they want? In my head, in my heart, I thought, what they want is not to die. Out of my mouth came three other words: temporary restraining order. With those words, I literally enacted the transformation from being a full human being to being a lawyer. In the summer of 1987, just a few weeks earlier, and 6 full years and 100,000 deaths into the epidemic, the President of the United States, Ronald Reagan, had uttered the word AIDS for the first time. And he had taken the action of the bold leader that he was. He had established a commission to study the subject, asking for a report in a year. 50,000 more Americans would die of AIDS that year. The President appointed 13 people to the commission, not one a person living with AIDS, and only one, a geneticist with some experience in retroviruses, an openly gay man. When pressed to explain the absence of the most highly impacted community on the commission, the President's domestic policy advisor told the New York Times the following, and I quote, "I would be very surprised if an administration opposed to making appointments on the basis of race or sex would agree to make an appointment based on bedroom habits." End quote. I happen to know that a little-known law, the Federal Advisory Committee Act, required that membership on federal advisory committees be fairly balanced in terms of viewpoint presented. Our hope was to use that language to have a court order the government to expand the commission to include people with AIDS, my temporary restraining order. Put simply, we were looking to have some of the group that I represented, people with AIDS, be recognized as members of the group that the Attorney General purported to represent, the people of the United States. As such, my stated mission was to explain to a court what a group wanted. The group was an amorphous collection of people which at that point in history likely consisted of somewhere between 500,000 and 1 million people, the vast majority of whom had no idea they were members of the group, and but a nascent capacity to find out. Rule 23 of the Federal Rules of Civil Procedure enabled me to bring them together into a class and to stand before a judge purporting to speak for them. But it would not be unfair to say that the group I purported to represent in court was in many ways a figment of my imagination. What would it mean to represent such a group? Did its members have common desires and interests other than those I made up for them? How could I know? Did it matter that I was, by one of those arbitrary twists of fate, not a member of the group? I had a client, the National Association of People with AIDS, that attempted to organize the group. The group's founder and its leader, my friend Michael Callan, was seated at the council table with me. In theory, he was the group's real champion, there to tell me what the group wanted, as he surely knew better than I did. But did he? Since 99% of the class members we each purported to represent were not members of the formal group for which Michael immediately spoke, he too was engaging in a projection of the group's interests, even if from a different angle. Of course, it was not lost on me that although I imagined myself the group's champion, I had, after all, invented my job, invented the lawsuit, invented the class on whose behalf I was pursuing it, importuned my friends to serve as plaintiffs. The entire point of the lawsuit was to insist that only a member of the group itself could represent its interests on the AIDS Commission. Was speaking for a group in court different than speaking for it elsewhere? If so, why and in what ways? This is the first set of questions I confronted as a lawyer, and basically, I've never been able to move on. I've now spent 40 years thinking, teaching, writing, and lawyering about this single question. Who speaks for a group in court? My goal in the remaining time is to explain how this question has sustained nearly a half a century of thought. And the means by which I want to accomplish that is by walking you through 3 phases of a class action lawsuit 2 times. At the outset, the law insists that a class action lawsuit be initiated by a member of the class seeking relief. Class action is not what everyone thinks it is. We're getting a group together to go down to the courthouse. A class action is the exact opposite. It's a form of representative litigation. One member of the group goes down to the courthouse and litigates for the rest of the group. The class representative is the class's champion at the outset. The law is insistent on this fact. A class representative must be a member of the class. Her claims must be typical of the class. She must be capable of adequately representing the class. The class attorney cannot initiate a case without a class member that hits these marks. And class counsel spend considerable time and effort identifying, soliciting, and retaining such a class member in many cases. Now, fast forward to point 2. Like all the lawsuits, class actions settle. Class counsel negotiates the settlement agreement for the class. In doing so, she should be in contact with a class representative, just like any lawyer would consult her client in settling a case, as the class representative here stands in for the absent class members as the client. Sometimes class counsel recommends a settlement that the class representative rejects. Perhaps even moving forward to seek judicial approval is always required in class action over the class representative's objections. When that happens, the law is unambiguous in holding that a class representative cannot veto a settlement that class counsel deems satisfactory and that a court is willing to approve. Class counsel win and class representative loses. The law doesn't allow class litigation to be initiated without a class representative, but the law doesn't really care very much what the class representative thinks about a proposed settlement. Class counsel is the class's champion at settlement, but not for long. The shortest amount of time known to man is the time between a class action being approved and the attorneys moving for fees. In common fund cases where class counsel secured a lot of money, the fees are going to come out of the fund. At this point, class counsel is no longer the class's champion, but its opponent. Class counsel is asking the court to direct some of the client's money to them. Each dollar for the lawyer is one less dollar for the class. Who will be the class's champion now? Not the class representative. She likely knows little about attorney's fees and is too closely connected to class counsel. Indeed, if class counsel submit to the court a fee arrangement made in advance with the class representative, courts by and large scoff at that. Yet the absent class members are no better situated to come forward. They don't know anything about attorney's fees. They're not present in litigation. They have very little at stake. The law here is unambiguous in holding that it is the district court that must safeguard the class member's interest at the fee stage. The doctrine states that the court has a fiduciary duty to the absent class members. Let's take stock. At initiation, the law permits only a class member to be the class's champion. At settlement, the law ignores the class member, trusting the lawyer to be the class's champion. Then at fee time, the law fully distrusts both the class representatives and the lawyer and assigns to the judge the role of protecting the absent class members. At first cut, we see that the very idea of who speaks for a group in court permits at least 3 different answers within the arc of a simple class action lawsuit, which is kind of remarkable. What is even more remarkable is that while each of the 3 positions seems defensible, in fact, I'm now going to explain to you why each of the 3 things I just said is completely outrageous. Consider this. Because we consider a class action a form of representative litigation, we imagine it must be initiated by a member of the group. So far, so good. This is precisely the norm I was advocating for the AIDS Commission, and we feel the same way about legislative representatives who generally must be residents of the geographic areas they seek to represent. Here's the remarkable aspect of representative litigation. The class representative is self-appointed. She elects herself to represent the group. She walks down to the courthouse and files on behalf of the absent class members. Indeed, any class member anywhere in the country can walk into a court and file a class suit on behalf of a group of absent class members. I'm not aware of any other form of representation where this approach is so wholeheartedly adopted. Earlier this year, we had a presidential inauguration. If I had shown up and climbed up on the platform and announced that I had appointed myself to represent the people of the United States, I wish I had, I'd likely be sitting in a jail in El Salvador right now. But if I walked into court tomorrow and filed a class action lawsuit on behalf of all American citizens, I'd fully be permitted to represent that group, assuming the other components of class certification were met. We enable this form of representation because class member claims are typically so small, no one has the incentive to step forward. But given that, it might seem even more bizarre to embrace as the class's champion the kook who does so. Now, at settlement, class counsel is the class's champion. This too seems reasonable in the sense that the lawyer speaks for the client in court. But the single area in which a lawyer does not speak for her client is in defining the goals of the litigation. This is a choice only the client can make, not the lawyer. The lawyer is an agent, we're agents, the clients are the principal. Class action law flips this on its head, enabling the lawyer to define the outcome over the class representative's wishes. But the insult to legal ethics is even deeper. Remember, the class counsel could not have become the class's lawyer without a class representative starting the case. Yet, once she becomes the class's lawyer, class action law instructs her that her duty is to the larger class, and accordingly, she effectively dumps the class representative as an individual client. This too is clearly forbidden by legal ethics. The client can fire the lawyer, but not vice versa. In fact, at its heart, class counsel's relationship with the class representative is a purely parasitic relationship that upsets everything we know about legal ethics. At fee time, the court has a fiduciary duty to the class and is its champion. This might be the most bizarre deviation from norms of all. In our judicial system, the court is a passive and as neutral as between the parties, while a fiduciary has a duty to act and to act in the best interests of her wards. Courts are not well equipped to perform these functions, but that's not even the worst part. The judge who is a fiduciary is also the same judge who adjudicates the contest between her own wards, the class, and the class's lawyer. This violates just about every single norm of judicial ethics. I've written here, deep breath. I can just feel everyone sensing that this is now going to culminate with me revealing the right answer to each of these peculiarities in the classic tradition of the Harvard Law School, thereby in kind of demonstrating my entitlement to the proffered chair. And they might even take the cover off it. I'm afraid those hopes will be dashed. I'm going to close by telling you that these three issues don't generate right answers as much as they generate more questions, and that this is the nature of procedure. Procedure owns its status as a punchline when it's understood as a dreaded book of settled rules, all adjacent to the main event. What I've tried to show you this afternoon is that procedure is a set of standards, not just rules, that are up for grabs, far from settled, and each one of them is fully outcome determinative, substantive, not a salad, but a main course. Bruce Bromley, for whom my new chair is named, entered Harvard Law School in 1914, as John said, at the outset of World War I. He actually didn't make it to his graduation. He reported for duty as 3L year, and he received his 1917 degree after the war. I entered Harvard Law School 70 years later in the midst of a different sort of war, one that has now claimed the lives of at least twice as many people in the world than died in the Great War, and 5 times as many Americans. 40 years on, we are now in the midst of yet another type of war. 24 days ago, the President of the United States declared that our country had been invaded by members of the TDA gang, acting as agents of the Venezuelan government. He ordered that they be rounded up and immediately deported, relying on the Alien Enemies Act of 1791 to allege that we are so essentially at war that it was necessary to forego individualized proceedings, to suspend, that is, due process of law. The ACLU filed a suit to interdict the emergency deportations, securing a temporary restraining order to stop the planes that were in the process of flying the Venezuelans to El Salvador. The country has been transfixed by the question of whether the Trump administration obeyed the court order. Less commented upon are two underlying matters. The ACLU's suit, aiming to apply to all the deportees, is a class action lawsuit. Several of the class representatives allege they were wrongly rounded up as they are not members of the TDA. In the current phase of the litigation in the Supreme Court, the government argued that such persons who were not themselves members of the targeted group could not adequately represent the class as required by Rule 23. I spent much of the past several weeks working with the ACLU to respond to that contention, crafting an argument that the misidentified could be the champions of the properly identified for the simple reason that all sought the same legal relief, due process of law. Against all odds, just last night, the 9 justices, agreeing on very little, appeared all to support the proposition that each deportee was in fact entitled to some kind of hearing, to due process. The framers bequeathed to us a constitution that guarantees, above all else, procedure. They could promise no one litigant that she would win her lawsuit. So instead, they promised all litigants that they would not be deprived of life, liberty, or prosperity without a fair procedure, without due process of law. The framers used a general phrase, and they left it to subsequent generations to work out its meaning. Every generation gets the due process clause that it deserves, based on the issues of its day and the efforts of its citizens, especially its lawyers and its law students, in confronting those issues. Teaching civil procedure has been an honor, not a punchline, as it has enabled me to be part of my generation's effort to give meaning to our nation's most cherished constitutional value. That Harvard Law School has given me a home for this project, surrounded me with wonderful colleagues, and even better, each September sent in another group of 85 extraordinary law students for me to orient to this purpose. Dayenu, that would be enough. That you've now bestowed upon me these pieces of wood, this chair, my teacher's chair, is truly a gift. So thank you all very, very much.
Sure. So actually, I was so delighted, Bill, that you talked at the end about last night's order, because actually, when I read the order, the court's opinion, I thought of civil procedure, and I thought,
isn't that a great moment in life?
I was going to ask the question about that case, and how it highlighted how if you want to be like a great lawyer of any kind, whether it's a human rights lawyer, an environmental lawyer, you have to know civil procedure, because that's the language of the courts. So I was interested you pinpointed the part of that they all agreed on, which is all 9 justices, and Kavanaugh goes on at length, agreed on the fact that there's a due process right. They all have.
They even cited Mullane versus Central Hanover Bank and Trust Company. Wasn't that bizarre?
Right?
Yeah.
But then there's the other part they don't agree about.
A lot.
And that is, do you have any views on it? In other words, I don't know the TRO. I don't know the habeas stuff. I don't know if Sotomayor is right when she says, even if they're right about that, it's a question of equity. I'd be really curious to your views on that other question, not the one they agreed about, but the one they disagreed about.
Yeah. So to step back, just to kind of bring everyone up to speed here, as you read about this in the paper, one thing we're all familiar with, Trump's doing a lot. There's a lot of lawsuits against what he's doing. One question in all the lawsuits is, what jurisdiction are they going to be in? Because it's often outcome determinative. This is forum shopping at its best. And those opposing the Trump policies are filing actually here in Boston. The First Circuit's a good circuit. The DC courts have been good. The exact opposite happened during the Biden years when there were challenges to Biden's policies. Conservative lawyers would file in Texas and Fifth Circuit. So there's this fight about who's going to hear the case in almost all of these cases. And what was interesting about last night's order is they essentially, the case had been filed by the ACLU in the District of Columbia. We had a District of Columbia federal district court judge. It went up to the DC Circuit already, and they already decided the TRO was okay. And the court basically said the case should have been filed in Texas, which is the death of the case. I mean, let's be honest about this. And in large part, what's fascinating to me about everything that's going on with the deportations is that not only are we forum shopping, which is normal. If no one forum shopped, I wouldn't have a course. So the forum shopping part's normal. What's amazing is that what the deportations are doing is they're grabbing people and immediately moving them to Texas. And so it's not a situation where lawyers are running around trying to find the right place. They're actually placing human bodies in places where they know the judges will be sympathetic to their side of the argument. So the woman from Tufts who was rounded up on the street was immediately taken out and down to Texas. The reason for all of this is if you have to file a habeas corpus petition to get released, you have to file in the district where the person's body is, literally habeas corpus, bring up the body. And so by moving everyone to Texas, and so one thing that happened last night was twofold. One is they said this was really all about habeas and not a direct challenge to the deportation. And once it was about habeas, then it has to be filed in Texas. So there were like two moves there. Yeah. On the former one, was it really a habeas petition or wasn't it? I'm no expert on this either, but at the very first hearing in the TRO, Boasberg, the judge in DC, said very much, you don't want to bring the habeas, right? And partly he did that because he knew that people weren't there anymore. The other reason he did it is it's very hard to bring a class action for habeas claims because they're kind of by nature individualized in some sense. So the current situation, Richard, we're in Texas, not good for the ACLU. It looks like habeas, so it looks like maybe individualized rather than group. So I think that's a lot of what was being fought out yesterday.
Great. Thank you so much for this. And let me say publicly, I love civil procedure. I've even taught civil procedure, although very badly compared to our honoree. A lot of what you said about the conundrums of representation, which was very beautifully put and elegantly put, makes me think of my former colleague at Vanderbilt, Richard Nagareta, a wonderful scholar in his own right. And his view, I'm sure I'm getting it wrong, but as I understood it was, all the things you talked about and all the conundrums and puzzles you raised are good evidence that aggregate litigation should not be understood as A versus B litigation, that all of these problems and puzzles indicate that really it's a mistake to even think of aggregate litigation on the traditional litigation model. It's really a form of regulation. It's a form of regulation that's very well disguised and looks a lot like traditional litigation, but once you poke all the holes in it that you just poked in it, it turns out it's really just a distinctive form of government regulation, which might explain why the various actors actually are doing the things that they're doing and resolve some of the puzzles that you mentioned. So I'm just curious if you have a reaction to that.
I always like, John, when you say A versus B litigation, because that's your favorite thing. You think that's the only thing that exists. Yeah, tort is just a single person harming another person. Yeah. So I've actually been thinking about this a lot recently. I do feel like there are two ideas about a class action. One idea is it's representative litigation, and one idea is it's group litigation. And the idea that it's representative litigation, if followed through literally, which we don't, and this is where Richard, I think, was right, would be like this. You take the one representative's case, you try it, and then everyone else in the group gets whatever that one person got. That's a purely form of representative litigation, and it remains in your one-on-one format. In fact, you could go even further, and I kind of believe this. If you want to settle the whole group's cases, you could do the same thing. You settle the one person's case, and then you apply the settlement in a group. Anyone who doesn't like it opts out. What's happened to our class action laws, we don't do any of that anymore. We, in fact, lawyers, in fact, see the whole thing as a big settlement, as group litigation, and they settle the group's claims en masse. I actually think I have the title for an article unwritten, and we walk around with these in our head. This one's called Why a Settlement Class Action is Not a Class Action. And I think it's close to Richard's idea. It's group litigation, which feels a little bit like Richard thought what an administrative agency should be doing. That part I never understood. Just because it's a group doesn't mean that their group's claims can't be processed by a court. It does, you're right, explain some of the peculiarities I was talking about. But you then have to figure out if you're going to process a group's claim by a court, are you going to do it in a representative framework? Or are you going to find some other framework for how to think about processing the claims in that particular way? Yeah. Dick.
So, Bill, this was just a dauntingly, amazingly wonderful, wonderful talk. And I thank you so much for it, as I'm sure everybody here does. One of the things you said at the very end just captured my imagination, and it was the idea that every generation gets the due process it deserves. And it sort of made me think, well, you know, who's the group here? What's the generation? Who are the representatives? And as I thought about those questions, I didn't know what the answers would be. And I don't really expect you to answer the questions in those terms, but it would be fascinating to me to hear you reflect over the time since you started litigating these issues, whether you think the due process that has been available to people has become better or worse over that time, and whichever it is, whom do you primarily hold responsible for that in more concrete terms than every generation gets what it deserves?
I think there's a course in an answer to that question, Dick. Great question. There's one story about what's happened in our lifetimes, which goes from the Warren Court insisting on more due process and more individualized processing and more care, and then the Berger Court and the Rehnquist Court retrenching from that and allowing less due process to be. So there's kind of a political story about that, but I feel like there's all kinds of other things going on that it's hard to capture in that simple way. For instance, the American Law Institute recently started a new project to talk about the mass processing in state court of tens of thousands of types of claims that are repetitive credit collection actions. And there are tens of thousands of credit card companies collecting on people who've reneged, and the state courts don't give very much due process in those cases. So a lot, depends on, and then there's the whole question about arbitration clauses and doing away with litigation. So there are all these different pockets in which due process has come and gone in various ways. As I was writing this speech, I was thinking to myself about this very issue at the end, and I thought to myself, and I say this in part because there's a current move in the academy away from courts, and I resist it. And part of the reason I resist it is I wouldn't have a job anymore, and I'm kind of litigator through and through. So I was trying to come up with a lofty reason that I resist it. And I feel like it connects to your point, which is I feel like at the end of the day, what due process is a requirement that reasons be given. And to have a forum which forces people in power to give reasons for what they do is perhaps, I think, the grandiloquent part of this. And I really feel like that's what everyone's hoping the court system will do right now, because there's a raw exercise of power without a lot of reasons given for it that seem genuine. And there's a sense in which due process will insist that people in power give reasons and will provide a forum for scrutinizing the legitimacy of those reasons in ways that politics doesn't. So I still hold out that loftier goal. I still imagine myself part of that process. But at the same time, I don't want to pretend there's not all these other processes going on all over the place. So it's hard to have a singular answer. I kind of feel like in some ways my generation maybe failed people who are processed through state courts on a steamroller without any opportunity to be heard when their houses are taken away from them or somewhere. So it depends where you look. I know that's not a totally satisfying answer, but yeah.
One more question, student there?
You guys asked so many questions during the class. Now all of a sudden, no one has any questions. No one wants to talk about Mrs. Kroger's supplemental jurisdiction problem.
Hi, Professor Rubenstein.
You are the class representative.
I am now. It seems like there's the flip side of an opportunity to be heard is that the person who's supposed to hear you is actually listening. And we've seen, maybe the most in my adult lifetime, the powers of the court seem to be tested in terms of ordering a plane to turn around, and it sort of relies on a fiction that the word will portend the resources of the state to follow it and bring it to life, and that element seems really stressed right now about the courts and about the power of litigation. And I'm curious to know just a bit of your thoughts on where that side of things stand and what we might expect.
Yeah, that's a terrific question. I think I said this in some place. It feels like the country's transfixed by the question of whether the Trump administration will obey court orders. I'm going to say something a little unpopular about this, which is I don't think we're there yet, although we might be. So I appreciate everyone's anxiety about this. Being involved in the litigation over the deportations has fascinated me for one reason. The administration's reliance on the Alien Enemies Act is, in my opinion, ridiculous, but is an attempt to give a legal framework to the use of power. And so it's the often extreme, but nonetheless utilized commitment somewhere in there to pretend there's some legal basis for what they're doing, which still has the feel of being part of a legal system and wanting to work through the legal system. We might disagree about whether the Alien Enemies Act really has any meaning here, but their use of it, their reliance on it, rather than relying on nothing, demonstrates some way in which they're still trying to think of law as being in play in some way. I think the ultimate question will become, how does the Supreme Court think about these questions? And then, as you suggest, what happens if there's an order that they don't want to obey? A lot of the stuff, the Boasberg order, turn the planes around, it was kind of fun. I did think to myself, like, really, they're going to turn the planes around? On the other hand, I do feel like the argument that someone's in El Salvador in prison unfairly, wrongly, and we can't get them back, that seems kind of ridiculous to me too. So it's an interesting time to watch the interplay of this. I would just say this, keep your eye as well on, as the Trump administration does things, watch the extent to which it's relying on legal principles for what's it doing. We can say to ourselves, oh, we don't think that's a right application of the law, but it's the moment at which they stop actually pointing to any law whatsoever. That starts worrying me even more in that sense. What a depressing note to stop on. There are drinks to be had. Oh.
It's not all depressing. First, we have the final act of the chair bestowal ceremony, which is we come over here and we do the big reveal. Ready? I have no idea what's under here. Ta-da! Thank you all for coming to this lovely occasion. Nice pieces of wood. Good, excellent. Thank you all for coming so much. There is a reception to follow across the hall. I hope everyone will take advantage of that, and please join me one more time in congratulating the